Good, good, good. Not that. I can't, yeah. But other than that, I really liked it. And when I was there, you know, you might have heavy traffic in the morning, afternoon, and I'd go by, my wife has family there in Round Rock, and that traffic is all the time on the freeways and stuff.
I was going to Williamson, I go to Williamson 3 days a week, okay, every morning I did it on 130. The entire southbound, I was going north, the entire southbound was bumper to bumper every morning.
So you went against traffic.
Against traffic, I mean, you drive me insane. If I lived there and had to go on Mopac all the time, or I-35, it'd have to be carried out.
Yes, yes, so that Mopac is a parking lot.
I'm in the eye of the hurricane, that's it. See, Central also, the High Park campus,
Yeah.
that little shit there, you know, it's just.
Well, yeah. Do you have a grocery store and everything where you can get to easy?
Let's see, I go to, yeah, there's some hippie grocery store involved on 45th, and better yet, there's that flagship but at 40 Central Market,
Yeah.
it's like all these great AAA goods and stuff.
Oh, great.
Doesn't make losing weight any easier. but
Well,
It's available.
we finally got an HEB in Lubbock, and that's where I get a lot of my low carb breads, and they had selection on everything.
Well, if you're ever down there, you ever been to that place? It's quite, it's not like a heat, I mean, it's under their banner.
Yeah.
It's just premium, everything in there is
Okay.
high grade, somehow.
Yeah. And I guess they have Tom Thumb and all that other stuff like they used to.
No.
Okay, yeah, okay.
Plus, you gotta remember, all I know about is, it's like when I went to school there, same thing. All I'm good for, any knowledge of, is that little bubble in the center of town.
But
That's it.
did you fly in or drive?
Drove,
Do you have a base in Lubbock anymore, or is it gone?
it's gone.
How'd you watch it?
I lost her.
Oh, I'm so sorry to hear that.
She was 80, man. She was 9 years old when I was
Okay.
on for her. She was even older.
David, I am so sorry I brought that up. I knew that.
Yeah, and we were down there. She was helping me. We moved down there because her health was failing.
Okay.
She had she survived cancer surgery in Indiana, so she was cancer free.
Really?
She beat that, but she had congenital heart failure that nobody beats. Congenital heart failure.
Well, please forgive me for bringing that up. I just did not know.
Oh, it's okay.
Yeah.
You know, was on
Yeah.
everything. She was wall partner, wife, and everything
Yes,
else. You know,
yes,
so
sir.
kind of a gaping hole.
Yes, sir. Yes, sir.
Trying to stay busy to work on it. Somewhat busy. She was an unbelievable personality, man. When we first went out of school there, she didn't have to come. She got PI cases, all that sort of thing. I didn't know anyone. She was like mother superior in half the city, you know?
You think they mind if I got one of those waters?
Nope, go for it,
You
sir.
want one?
It's interesting.
Or did you drive in or fly? My name is Wade Jackson. I used to work for a DA's office for forever, but I'm semi-retired now.
My boss, Audrey Lewis, told me
Okay,
that they
I
wanted me
know.
to be here and watch.
I like her.
the-
Oh, no, sir. No, sir. I like Audrey. I really do. I guess you just start a new term and everything then.
Yeah, it's their third term.
Good deal. Good deal. No, I'm mostly retired. I just write a few appeals for a few DAs around Lubbock.
Oh, okay.
Wait, how many times you been in the reporting? There's a reason why I'm asking that.
I've been on the,
In the Southwest reporting,
oh,
a lot, right?
yeah,
Well, and Wilco, both counties get work. I had to do my life story, like 50 pages. It turned out I've been a reporter 20 times.
All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session. Please be seated. The next case on this afternoon's docket and the last case is cause number 0724-00174-CR. Jeremy Neal Atkinson versus the state of Texas. What says appellant and what says the state?
stage president.
You'll each have 20 minutes to argue, and then the appellant has an additional 5-minute rebuttal. Any questions before we get started?
No,
Not on stage.
Okay, Mr. Crook,
thank you. This is of course a murder case, automatic life, the state waived the death penalty. Where the appellant's bringing 2 points of error on appeal, one pertaining to charge error and one an argument that the state's evidence was factually insufficient against the great weight and preponderance of the evidence for the affirmative defense of insanity. As long as I'm running wild here, I want to address point one briefly before moving on to point two. Point one has some case law difficulties. The way the state conceptualized in its brief was actually not a bad manner for looking at the problem at point one, which I'll try to be concise about. One was in fact the indictment validly amended or not? And two, the question of waiver, given the fact that the appellant at trial through counsel did not make any objection of any sort to the state's amended indictment. The record as to the state's amending the indictment shows, first of all, the original indictment, which I actually had to do a motion to supplement the record to get into the clerk's record, which I found rather puzzling. But the original indictment alleged murder and furtherance of robbery with one manner and means, namely shooting. And then they amended or purported to amend the indictment to add a second manner and means, stabbing. So the
Is it your position that the order amending the indictment does not contain the amended language, and that's what's wrong with it?
well, for a long time in the state, when it was more formalistic, you couldn't amend the indictment without actually interpolating the new language in the old indictment. Now that
Writing on
Ronnie,
the actual indictment.
yes, yeah, Ronnie, for years. Okay, and then of course Ronnie came along about 2000 or so, that Court of Criminal Appeals case where they took a step back from, I guess, what you could argue was excessive formalism, and indulged in some rather loose language where they said interlineating on the actual charging instrument is not required. It's not the only way to do it without being terribly specific about what the other ways were. So since then, there have been various case law holdings, including, what is it, Huerta by this court, where this court, I mean, to be blunt about it, took the same liberalizing or less stiff approach to what exactly do you have to do to amend. There are other cases that say several of the other published opinions addressing the problem, two or three anyway, it's in there, excuse the situation or allow or claim, assert that the amendment was effectively indicted in those cases because not only was the, well, excuse me, they didn't interlineate on the original charging instrument in the record, but they did, in fact, take a copy of the charging instrument and interlineate on that. So from those published cases, there's kind of a, not absolute, given a couple of other cases I got to mention, but there was a sort of compromise between pre-Ronnie and okay, post-Ronnie. We're going to say it's okay if you interlineate on a copy of the charging instrument. And there are other approaches. Now, there are unpublished opinions that kind of get tired of the whole topic and basically say it's fine as long as there's notice, no objection, and the amended indictment appears in the record. There are at least three unpublished opinions. Admittedly, all this seems to be the trend somewhat. And then if
Well, and that's the case here.
sorry,
There was an amended indictment.
Yes.
In
there's
the
a,
record.
yes, ma'am. Yes, Your Honor, there's a, you know, amended indictment with no interlineations on any original charging instrument. I was mistaken in the original brief. The trial court did sign the motion to amend, but later did not, as noticing more recently, did not, which is perhaps a 2811 issue under CCP, did not sign the state's copy of the amended indictment, if memory serves. Okay, so it's a bit of a gray area.
Well, if you look in the clerk's record, page 6, I think the amended indictment is filed by Judge Phelan. And of course, he does have a rather distinctive signature in it. It's legible. Some judges in our district, it's kind of hard to tell. But my question, the grand jury foreman didn't sign the amended indictment. Is that required if you're only amending the manner and means?
You know, I'm really not sure. I didn't look at that angle to be blunt about it. I mean, I've filed objections myself before where they do something I think is outside that would require a grand jury constitutionally, but that's not really the thrust of the brief or the complaint here.
I was just curious.
So it's not, it's just conceivable that a PDR, and then there's Huerta in this court, which took essentially the same position as the unpublished opinions I was referring to and said, no harm, no foul, where the the amendment, there's a motion to amend essentially, and the trial court grants it, and the new indictment appears in the record, and there's no objection. The situation passes muster. That may be the new normal. I threw the point in because appellate defense lawyers tend to be obsessive about charge issues anyway, or ought to be.
Well, you've got a problem there too.
Sorry?
Because you have a problem there too, in that not only was there no objection to the amended indictment, there was no objection at all to the jury charge.
Right now, and the state's working on that line of country, but the thing is, I don't personally, of the three prongs, like was it amended validly, was there a waiver, and the harm question, to me, the defense is on the strongest ground in the middle one, despite your inquiry, because the defense position, win, lose, or draw, is that he wasn't, the point of that on appeal is under 3614. It's 3614 expressly recognizes fundamental error. Of course, you're probably going to lose if you don't object under the egregious Almanza standard, but it doesn't speak of waiver. It's separating it conceptually to me, and you may not agree, but whatever valid points you had about him waiving any complaint to the indictment of such, and I agree he did. Okay, not a beat out of him about the indictment. That conceptual approach does not carry over when you're looking at charge error. On appeal, I'm claiming charge error, not wrongful denial of a motion to quash or something of that sort.
This is a result-oriented offense, right?
Yeah.
So does
Yes,
manner
sir.
and means matter? in a trial?
Well, if you're getting ahead to the question of harm, let me just say that it's reflexive maybe for an appellate lawyer to try to make something of a manner of means being incorrectly added, if you buy that, to the charge. Now, as far as harm goes, ultimately, egregious harm, I mean, it's there theoretically. I'll just leave it to the court. There's no question but that he intentionally murdered the woman, his mother, So harm is, I feel better about the second inquiry waiver. I'm prepared to stoutly deny waiver as far as it goes, but I'll just leave the harm thing. Like,
Understood. Well, you said you had a second argument that you wanted to talk about.
yes, sir. The second point of error, okay, which I think is considerably more up for grabs, or at least in the defense point of view, is of course, the assertion that the evidence was factually insufficient to show.
Before you get into that, you have phrased your issue that the trial court erred by letting the case go to the jury, as the jury's verdict rejecting appellant's affirmative defense of insanity was against the great weight and preponderance of the evidence. Are you saying that the judge erred in not granting a directed verdict?
Well, it's to me, it's 6 of one or half a dozen of the other. It's evidence insufficiency is a species of fundamental error. So I could have worded it differently and just said, however I worded it exactly, the verdict cannot stand due to the factual insufficiency, due to the fact that the jury's finding was against the great weight and preponderance of the evidence, in that the preponderance of the evidence amply showed insanity as a criminal law concept, or that's.
So you're not, there is no directed verdict.
Well, no, there was no motion for direct.
Right.
Well, actually, I'm not immediately certain, but it's
Well, I
possible there
couldn't
was.
find one, and you're not contending that there was one.
No,
Your argument is no reasonable juror could have answered that question.
correct, correct.
That's your argument.
Manifest injustice because the finding was against the great weight and preponderance of the evidence. insanity, the affirmative defense, the classic. Okay, so, some rebuttal, I guess we'll keep into this. The state in its brief made various points that, to refute the claim of, insanity, of proof of insanity by preponderance, by talking about, evidence by lay witnesses that he knew right from wrong, and so forth, evidence of the wrongfulness of his conduct and so on. Now, the, fact is, the crux of the defense case was three experts. There was there were three doctors who testified, and excuse me, let me get to the location here. One of them, Dr. Nyberg, gave the lengthiest testimony. There was also Dr. Joyner, and the first witness was Dr. Ira Thomas, who saw appellant 8 or 9 weeks after the murder. Now, he basically said, as did the other two, without a formal diagnosis, that he was schizophrenic. Okay, Thomas did not think he was malingering. He, quote, suspected, close quote, appellants suffered from schizophrenia. He obviously needed psychiatric services. And a little more dramatic, appellant was talking to him about, appellant in Thomas's presence was having conversations with potato chips, having conversations with light fixtures, talking with the dead, which he did quite a lot. He also talked to the washing machine, or the washer, whatever, and also heard voices coming through the walls, and also heard what the power lines were saying, which I thought was descriptive language that sort of transcended any lawyer blah blah about the concept of insanity. For starters, granting that medical insanity does not necessarily coincide with legal insanity, still that's rather striking. Joyner, the second witness, opined that on the 3 occasions he saw appellant, he exhibited signs of schizophrenia on all 3 occasions. Nyberg, perhaps the lead defense witness, and the last one, for one thing, the state very properly, as I would if I were them, raised the question of voluntary intoxication, which if I have time, I want to address more later. Nyberg didn't buy that. He saw his behavior as being inconsistent with voluntary intoxication. He saw the video of his arrest. Again, some very striking details. Nyberg noted that he didn't believe he'd actually killed his mother, that his mother had supernatural powers and would come back to life. He fessed up to Nyberg, appellant did, about being a nature god and how various planets and railroads were going to come together to change the universe.
Dr. Nyberg, I think if I understand the record correctly, testified, looks like over in volume 14, that it could be that appellant killed his mother because he had mental health issues or substance abuse, or he killed his mother because he wanted the money and didn't like her.
Nyberg did not pretend to certainty, and I submit he would have been a real mountebank. And that's why they have the rule about lay witnesses being able to trump expert witnesses in case somebody's trying to pull some stuff. But Nyberg did not believe, on balance, that voluntary intoxication had a rule caused the episode. He noted Nyberg never got a rational explanation of the event out of appellant. Now,
What about his testimony, though, that it's possible that he killed his mother because he wanted the money and didn't like her? That seems to present the jury at least with a more than a scintilla of evidence that they could have said maybe that was the reason. They could have agreed with Nyberg.
well, there's some evidence of a robbery, although one of the lead detectives admitted he really had no direct proof that the money appellant had was his mother's money. But, and there was obviously this episode was the product on one level of animosity that had been building up between them for years. But
Sure. And I understand your argument that there's not sufficient evidence of a robbery. I understand that part. My point was this: if Dr. Nyberg said that was a possibility, that there was a motive, that it was a money motive, or he killed his mother because he didn't like her, that seems to undermine the mental illness argument. or
It does, I get, or could be seen as doing so, except that remember, he had to prove his insanity defense by a preponderance, okay? Not the highest standard. And also that at various times, he gave various versions. Not Nyberg believed he didn't know right from wrong, okay? And I'm already running out of time fast. The state produced or naturally cited Rufkin, this lead case defining insanity, saying that since I need to be brief here, the primary inquiry is whether the appellant knew right from wrong, obviously, based on the statutory language. Now, you've got various relatives saying you knew right from wrong, at least 3 relatives, if not 4, and a couple of police officers. If you look at that record, the same witnesses also provide ample indications that he was quite mad, or however you want to put it, because they all had anecdotal stuff. For example, the time he went to a next door neighbor's house at 4 a.m, knocked on the door and announced he was going to save them. You know, the same sister who testified he knew right from wrong in a 911 call was basically screaming that he was out of his mind. You know, the father who opined that he knew right from wrong had similar hairy stories. It's in the brief about bizarre behavior, as did the grandmother, or not so much the grandmother, but the father and the sister. And if you look at the cops who opined that he knew right from wrong, Rainey and Lopez, if I have the names right, he was well, for one thing, the arresting officer noted he was talking to an invisible person as he was being arrested. Okay, you just have to dredge through. I haven't got the time on the clock to read through all the stuff like that. Okay, he was talking. The jail staff reported him to mental health when he went in. Reyna and Lopez, after a pretty good cross by defense counsel, wound up admitting that he said a bunch of stuff that made no sense whatsoever. Somebody noted he was having trouble realizing what county he was in, unless I'm misreading. That sort of thing, like extremely disoriented comments and behavior. So what worries me about all this is with that mechanical test that Rufkin proffers. I know the Court of Criminal Appeals can't be second guessed, and the statutory inquiry is knowing right from wrong. What I'm afraid of is that in Texas practice, there's going to be an unduly mechanical approach to that. In other words, if somebody says he knew right from wrong, or if the defendant admits what he did was wrong, or what have you, verbal admissions of that type, there will be a temptation to just resolve the case on that level. Whereas somebody who later makes it plain to Nyberg, he really doesn't remember how his mother died, and at the time is seen talking to someone else and is reported by jail staff. And again, with state's counsel's points about there's deceptive behavior or him evincing arguably knowledge of guilt or trying to lay low from the cops in the immediate wake of the investigation. At the same time, when he's interviewed, he's happy to tell them all about killing his mother, arguably in furtherance of theft. And then only later does he snap to it and start wanting to retract, or he asks something like, am I going to take the rap for this? After being arrested and telling the police officers all about the killing, he seems to be surprised that they have any thought of him taking the rap for it. So to me, the danger of Rufkin is that the inquiry will end with, did somebody say he knew right from wrong? We're home free. Did he admit knowing in a given case, did the defendant admit knowing what he was doing was wrong? If a defendant is taxed with knowing killing someone is wrong, and later demonstrates a belief that person is still alive, which is in this record, for starters, or that the man, unidentified figure, killed him or was around, that was the various versions make no sense whatsoever, or what county he's in at one point. Knowing right from wrong, parroting, yes, it's wrong to kill your mother. That may be the exchange on the record in this case. Like, yes, it's wrong to kill someone. It's wrong to kill your mother. Well, if you, as it occurs, think some cosmic event is going on and you haven't really killed her anyway, it seems to me that ought to vitiate or undermine the basic construct that Rufkin is espousing on a superficial reading. If they're that far gone, how can they know right from wrong? If they're having an interplanetary exchange with multiple personalities and his mother's down, but she'll be back up, how is that knowing killing your mother is wrong exactly? just trying to assert that Rufkin is not a case that needs to be swallowed whole or looked at uncritically, despite the fact that it's the Court of Criminal Appeals, if someone is patently insane and can't form the logical foundation to understand the situation anyway, so, some superficial assertion, he knows right from wrong, or yes, it's wrong to kill your mother, shouldn't govern.
Your time is up. And you'll have a 5-minute rebuttal unless it's other questions. Thank you.
May it please the court.
Mr. Jackson.
Regarding issue 1, whether there was effective amendment to the indictment, I think I've laid forth in the brief that there was a motion to amend. There was a granting of that order by the trial court. There was an amended motion, which the trial court approved by a signature on the amendment. And then that original indictment was put in the record. And I think that satisfies all the Huerta requirements that this court has set forth regarding an effective amendment. In the event that it did not, the appellant was required to object to that prior to trial, and if he did not do so, he waived it under Texas Code Criminal Procedure and Article 1.14B. That is specifically set out, if you don't do it prior to trial, you waived it.
And this was like 4 months
That
before
is-
trial,
That is correct.
right, when it was amended.
That's correct. So it was 4 months. During voir dire, the defense counsel referenced the amended indictment, set forth the language of the amended indictment. So there's no argument that they did not know about the language of the amended indictment. And then we talk about jury charge error versus 1.114 error that you have to object to. I did cite a case called Trevino, where a court of appeals specifically addressed this, where the appellant alleged it was jury charge error because they used the language of the amended indictment, but the court said, no, you waived it under this one. You waived it because you didn't direct pre-trial. So the trial court was correct in charging the jury concerning the amended indictment.
Well, I guess if you don't, he's asserting jury charge error. But really it starts with, there was a lack of objection to the indictment.
Yes,
Or the amendment.
yes, if you didn't preserve error regarding the amended indictment, then the trial court is correct in charging the jury on the amended indictment language. And then I do references to what egregious harm is, even if this court finds that the error was preserved and jury charge error, he was not egregiously harmed, mainly because the amended indictment alleged shooting and strangling. All of the evidence at trial was the medical, he didn't want to call it medical examiner, forensic examiner, pathologist. Forensic pathologist said that she was alive. She was strangled first. She was alive. Then she was shot, and the shot was immediately terminal. So the evidence, overwhelming evidence at trial, was that she died as a result of a gunshot wound. Therefore, the potentially wrong, the jury would not have found that she was killed by stabbing based upon this record.
You meant strangulation.
Yeah, I
I
mean,
think there was stabbing that
Yeah,
used
no,
a
I'm
few
sorry,
times
yes.
throughout the brief.
Strangulation is correct. Strangulation is what, yes, she did not die as a result of the strangulation. She died as a result of the gunshot wound, and that is what the overwhelming evidence supported. And so he would not have been egregiously harmed by the addition of a additional means of strangulation being in the jury charge. And regarding the sufficiency of the evidence on the insanity, I'm not telling you there was not conflicting evidence. There was. I'm not telling you that there wasn't evidence that he was mentally ill. There was
a lot of evidence that he had, that the appellant had schizophrenia, but that is not where the insanity statute stops. In Rufkin states, and I've quoted in my brief, wrong, he has to know the difference between right and wrong means illegal. And Rufkin states, the question for deciding insanity is this: does the defendant factually know that society considers this conduct against the law, even though the defendant, due to his mental disease or defect, may think that the conduct is morally justified? Does he know that society thinks it's wrong, it's illegal? And I've set forth the evidence why I believe that the evidence that the jury was entitled to believe the evidence, to reject the insanity plea, that he had to prove by a preponderance of the evidence. And there's a lot of evidence that he did know the difference between right and wrong, and he knew that his conduct was illegal. Of paramount importance, he fled from the police. They show up at the scene. They say, he says, what's going on? Guy goes, she's in there. And then he gets in it, the appellant gets in his vehicle, tries to leave. The officer says, no, you need to stay here. And he said, he orders the policeman off the property, and then he leaves. He runs a red light, and he's caught at his father's house. His fleeing from the police is incredibly convincing evidence that he knew that his conduct was wrong. When the police officer arrived at the scene, the appellant said, my sister must have called you. So he knew that the police would be called due to his behavior and his lies to his sister. He knew his sister was suspicious of his lies to his sister throughout the entire day. His sister had been had texted several times with the appellant, and the appellant had lied to her about his whereabouts and the condition of his mother. That's, once again, incredibly damning evidence that he knew that his conduct was wrong when he lied about it to his sister. He lied about it to his grandmother. His own father saw him that day shortly after the murder and said, yes, he was different that day, but he knew the difference between right and wrong. So although there was one expert that testified that he did not know the difference between right and wrong, that same expert conceded at many times that, yes, it was reasonable for the family to conclude that appellant knew the difference between right and wrong. Yes, it's reasonable for the family to conclude that he lied to them. It's reasonable to conclude that he knew who the police were. I've tried to set forth some of this expert's testimony, and he was incredibly inarticulate regarding his opinion that appellant was insane. He was incredibly inarticulate in trying to defend that opinion when the other evidence was brought up that he knew the difference between right and wrong.
I think Mr. Crook's also arguing, though, that he thinks Rufkin is overly mechanical. I think that was the phrase he was using a while ago.
I don't know how to argue with when a court of criminal appeals says something. I don't know how to say that I think.
Is that a
wrong.
question that this court decides? We're governed, if the Court of Criminal Appeals wants to change it, that's their prerogative.
That's my understanding of precedence. But I don't think that it's categorically wrong. All of the case law discussing insanity says this is a complex ethical issue regarding the parameters of what society will use as a defense, and they typically leave it up to the jury. And it says we very rarely overturn a jury's determination in this regard because it involves so many legal and ethical components regarding how far the limitations of the defense will go. And that's once again a Court of Criminal Appeals case. So I don't really know how to argue that they're wrong because it is. When you have a defendant with mental illness, it's a tough thing. I'm not trying to say it's not, but if you're absolving somebody of criminal responsibility who strangles his mother, steals her money, and shoots her in the head, that's up for a jury to decide whether he should be have criminal responsibility for his actions. as long as the evidence is conflicting, and that I put in several cases where if there's evidence is conflicting, that's for the jury's determination. And there is conflicting evidence about whether he knew right from wrong, what was the extent of his mental health, and just to exacerbate the situation more, he was taking massive amounts of Adderall, at which the defendant's own expert says could impact upon his psychosis, his aggressiveness, his anger, his sleeplessness. So the jury was also entitled to say, the voluntary intoxication was involved in this case. And therefore, his insanity plea was, his insanity defense was negated by that also. But overall, the evidence is conflicting. But there is substantial evidence that he knew wrong from right. He knew that his actions were illegal. I get if I admit to this. So immediately afterwards, you've got lay witnesses, his own family members. The appellant puts in, well, his sister didn't see him that day, but I think the record reflects that the sister saw the confession that occurred immediately afterwards and was in communication with him. So she knew him, knew where he was at, had known him for 40 years. And she said that he knew the difference between right and wrong. And I think that's compelling evidence for the jury to rely on. And with his own father saying that he knew the difference between right and wrong. With his own grandmother, and a West Texas moment, did he know the difference between right and wrong? Well, he knew enough to lie to me. I mean, that was incredibly damning evidence that he knew the difference between right and wrong when he lied to his grandmother about it. So in sum, I think even though the evidence is conflicting, it is not manifestly unjust, and I think the evidence supports the jury's verdict. Thank you.
Any further questions? Thank you. Mr. Cook.
Counsel. This court did an opinion called Fortune versus State, 948 Southwest 2nd 511, where the state was arguing that since, unfortunately for it, its effort to amend the indictment had failed, the operative indictment was the original indictment. That's an Amarillo opinion. So as far as I want to get on to point two, but to me, of the three issues in point one, the arguing there was a waiver, maybe I'm missing something, is the weakest of the state's arguments on the 3 points, because again, I don't know how else to put it. It wasn't a motion to quash, it wasn't a direct objection to the charge, just an appellate lawyer treating it as a species of Almanza type fundamental error on appeal. So stand or fall on all that rather than any question of a 114 objection, as counsel noted. Now, the other opinion about waiver, Trevino, and it's possible I'm mistaken, but if that's the one I recall, the appellate court of Trevino opined that a defense counsel at trial shouldn't be permitted to reap the harvest or gain the benefit of lying behind the log and then doing it later. Okay. Now, turning to reality, I can assure you that you can believe it or not, and just a strong feeling I have, most trial lawyers in Texas, when they go into try a case, are not thinking about anything of the sort. It simply never came up. I don't see trial counsel was a fellow named Jesse Mendez. I'd give you 10-1 on a reasonably sized bet, if it were possible to fully resolve it, that he never even thought about it. I mean, that's a rather exotic line of attack. So to say they shouldn't be allowed to do that because those sneaky defense counsel guys shouldn't be allowed to get away with that after not bringing it to the court's attention, etc. Most of them, I submit, don't know that or ever think about it. There's that. Okay, now moving on. Right versus wrong, just real quick. No, I know why that's permitted. You can't have a system where somebody could break the bank by hiring some dishonest expert, laying down the law, and the state doesn't have one. It can't be an absolute. You can't say that lay testimony is dead on arrival against expert testimony, but it still goes to the weight. And remember, he's trying to prove it by preponderance. And the asking somebody if somebody else knows right from wrong normally would be completely, I would think, inadmissible under 701 for starters. under 701, this case law saying you're not allowed to, witness A can't purport to read witness B's mind. Also, these are, witnesses who in every instance, Raina, Lopez, the three relatives at least, I think everybody in sight said, yes, he knew right from wrong, while simultaneously describing over the years or around the time of the event, truly bizarre or delusional behavior. So their own assertion that he knew right from wrong is vitiated by their own anecdotal testimony. Putting that up against,
The grandmother testified that the appellant lied to her. That's a little bit different. I don't know that you've got to have expert testimony for that. She can offer her view on whether she thought he lied to her or not.
well, of course, but for the sister to blandly assert he knew right from wrong. Sure, he knew right from wrong when he was in high school. He knew right from wrong before the onset of gradual schizophrenia. He knew right from wrong perhaps when he wasn't having an acute delusional episode. Did he know right from wrong then? And she was crossed about her own 911 phone call, screaming he's out of his mind, or whatever she said exactly. He's out of his mind, that day. So, and the father has, if anything, even more bizarre testimony. You could refer to the record. The father digs up some anecdotal stuff about the jail, again, talking to things or people who aren't there. The father has his own war stories about completely bizarre behavior, and did note that on that day he'd never seen him look like that before. These are the family witnesses who are vouching for him knowing right from wrong.
I know we've talked about issue 2 for a while. I want to go back to issue 1 just briefly. What are you suggesting that the motion to quash or objection would have been on the indictment?
There wouldn't have been a valid motion to quash. Except you could argue, as I do, that it wasn't properly amended. There's always that argument.
It's just properly amended.
Yeah. Yes, sir. That's why, to me, it's charge error and not indictment error. No one's specifically picking a nit with the indictment. It just comes time for the jury charge. And if the indictment was not effectively amended, what are you going to use for a charging instrument to base the jury charge and guilt innocence on? As in Fortson, it would have to be the original indictment. Okay, and then voluntary intox too. Incidentally, I mean, opinions can differ, but I mean, to me, Nyberg's testimony was anything but ineffectual. It was quite impressive. He did not purport to assert certainty about these issues such as voluntary intoxication. However,
Your time is up. Would you like to complete your thought?
just if you look at the record, just to round out this thought, all three of the experts, particularly Nyberg, especially Nyberg, the other two didn't have much information, played down. Nyberg strongly opined that it was not Adderall that caused this business. He was the expert they relied on. Thank you.
Thank you, counsel. The case is submitted. And we appreciate your coming to Amarillo today to argue your case. Safe travels. Deputy, thank you for your help today.
All rise.